afternoon to everybody on the East Coast. This is Ryan Thurman, and I've got David Kaminsky and Joe Sansgrant logging in from Contact Center Compliance, Carlson and Messer LLP, and the offices of Joe Sansgrant. I think I said all that right. We are here today to talk about the new FCC rules that's kind of stirring up the industry, where the FCC put out a report in order with a number of rules around pre-recorded messages, call abandonment, and specifically about the revised rules to the TCPA for cell phone calls that we're going to cover in some depth today. So with that being said, the call, we are having to get a chance to record the call, so we're going to have that available for people that either log in late or for some of your colleagues that don't have access to the information. We'll also put that link out with the recording along with the slide deck so that you'll be able to print that off, take your notes, so you don't feel like you have to write everything down, because we do have quite a bit of content today. If you see us running around in an industry event, here's our picture and who we are. So if you don't know us, come say hello, and also get our contact information here as well. Some of the issues that we're going to talk about today. Most important question, one that I'm getting a lot of, is when do I need to comply with the FCC rules with dialers? When these rules take effect? Pre-recorded calls, what's happening there? Are those totally off the table, or are there still some exemptions left? What do I need to scrub for telemarketing calls? Meaning, what types of lists do I need to scrub against? What are my requirements?
Hi, Ryan. I'm here.
Hey, Joe. Thanks for joining us.
Yes, sorry for the delay.
So we're just going through the agenda here, and then we'll jump into the section I'm on about slide 3, just going through the things that we're going to cover, and then we're going to talk about what's the deal with preview dialing, what falls under TCPA, and what impact does this have with the FCC rules on dialers. So those are some of the things we're going to talk about. If you have questions during the presentation, the best thing to do is enter them on GoToMeeting of the questions section. Some people have already responded, and we'll pick out about 4 or 5 of them at the end. If we have time, maybe answer a few more. We do have a lot of content today. If we don't get to your question, we'll follow up with you after the webinar, but feel free to submit a question or let us know if you can't hear us well, anything like that. But again, we'll have it recorded. We'll get the slide deck out, so it's a common question people ask. So welcome, Joe, and welcome, David. I really appreciate you guys joining us today. We've got some real experts as far as FTC and FCC. David has spoken a lot at the ACA events and other things that I've seen him out here at the CAC with some of the collections stuff. Joe is an expert specifically on the FTC and FCC rules, so he's going to kind of these guys are going to kind of kick it off. I'm going to hand it over to them. We're going to talk about some of the background and how we got to these rules, specifically about pre-recorded rules. And before we actually get started, I did have a poll that I'm going to put up there, which just kind of will help us better understand what type of technology, what type of dialers and communications technologies people are using in the contacts industry. So feel free to fill that out, and then as we get into the next couple of slides, I'll announce the results in terms of whether people use them pre-recorded or predictive dialers, etc. So the poll's open. Feel free to fill that out, and I'll hand it off to David and Joe.
Thanks, Ryan. Thanks for inviting me. This is David Kaminsky. Everyone, thank you for participating.
And this is Joe Sansgrant. Dave, I guess I go first, right?
Yes, sir.
All right, beautiful. Now, where are we? All right. So, as everybody knows, the FCC just came out with a bunch of changes to its rules. And let me get this GoToWebinar thing going here. Well, anyway, Ryan, you're on slide 4, background, correct?
Correct.
Okay, great. And so just a little bit of background on, how it is that we got to this moment where the FCC issued a set of sweeping rules governing its auto dialer pre-recorded calling regulations. going back 2008, I don't know if anybody remembers, but the Federal Trade Commission decided to go ahead and change its pre-recorded rules. And the big thing was that any telemarketing message delivered via a pre-recorded message requires, starting in 2008, express written consent. Beyond that, the FTC said, hey, you have to have an opt-out mechanism in place, and this could be a key press of some sort that the consumer presses or a voice-activated mechanism. It seems like most people have opted for the key press. A major point that I made at the time that the FTC came out with these rules was that it's technology, what I call agnostic, and this is in contrast to the FCC regulations. And what I mean by technology agnostic is that the FTC rule, it doesn't matter how it is you're making the call, whether it's an automated dialer or whether it's a landline or whether it's manual dialing, doesn't matter. And it doesn't matter if the call is being made to a landline or a wireless number. The FTC just says if you are sending off a pre-recorded message for telemarketing purposes, you have to have express written consent. And then the FTC also addressed call abandonment rules, and it changed its rules so that telemarketers have to measure their abandonment rate on a 30-day per campaign standard measured every successive 30 days. And that kind of, we might address that a little bit further on, the difference between successive and rolling. But then, fast forward to January of 2010, the FCC comes out with a notice of proposed rulemaking, and hey, correctly, the FCC concludes that its pre-recorded rules are different. But based upon a review of the NPRM, and as I wrote about at the time, the FCC it has to issue regulations in accordance with the Telephone Consumer Protection Act. And the way that the TCPA is written, it divides up how the FCC regulates telecommunications based upon how the call is being completed and to what number the call is being placed to. And this kind of ties the hands of the FCC a little bit, and as I pointed out at the time, this might cause some difficulties for the FCC in trying to really align its rules with the Federal Trade Commission. And then also, at the time, the FCC, in its proposed rulemaking, it came out with not a successive abandonment measurement, but a rolling abandonment measurement. It's not a huge difference. It's just that, why couldn't the FCC just come out and say, hey, let's adopt a successive 30-day abandonment measurement rule as opposed to rolling? All right, so let's move on to the next slide. And all right, so the first issue addressed by the FCC in its recent rulemaking is predictive dialer pre-recorded calls to cell phones. Okay, the old rule is that you can't make predictive dial pre-recorded calls to cell phones without prior express consent. And I put in PDQ just because I thought that was funny. The new rule, the FCC creates two categories. First category is telemarketing, predictive dialer, pre-recorded calls to cell phones, and the second category is all other such calls to cell phones. All right, so we have those two main categories. So let's take a look at category one. We divide this up into subcategories. So let's take a look at calls that constitute telemarketing in general. You're delivering a predictive dial or a pre-recorded call to a cell phone, and you're doing telemarketing. Well, guess what? You have to have prior express written consent in order to do so. The next category is telemarketing calls made by a tax-exempt nonprofit organization. Okay? The FCC kept its existing rule, which means you just have to have prior express consent. You don't have to have writing if you're a tax-exempt nonprofit organization and you're calling up for purposes of fundraising. And then the last category is calls that are covered under HIPAA, calls that are made by a covered entity as defined under the HIPAA regulations. Not even going to get into that. That's a whole separate category. if anybody has questions on that, feel free to contact me later after this webinar. And then the next category, category 2, is the catch-all. These are all predictive dial pre-recorded calls to cell phones other than the ones that appear in category 1 above. And for these, and these are informational, non-telemarketing calls, and the FCC actually identifies a bunch of different calls in this category, such as research or survey messages, nonprofit fundraising messages, informational calls by school boards, political candidates, airline notification services, bank account fraud services, and debt collectors. For these calls, you just have to have prior express consent only. So in other words, same rule as applied before, and the FCC is making it clear that you have to have prior express consent for those calls. Okay, next slide. The second category, and remember, the FCC has to work within the framework of the Telephone Consumer Protection Act, and this is how the TCPA divides up the telemarketing, telecommunications world. So now we have pre-recorded calls to residential lines. The old rule, you have to have prior express consent if you want to deliver a pre-recorded telemarketing call to a residential line. And this was very welcome to the industry, especially to those entities that were not covered by the FTC's telemarketing sales rule, because this was a much more lenient rule. All you need is prior express consent. You don't need prior express written consent. And then on top of that, if you have an established business relationship with the person to whom you're delivering the pre-recorded call, then no prior express consent is required. Kind of hearkening back to August of 2008, the FTC removed that EBR exemption and required express written consent. All right. So bottom line here, the FCC just went ahead and followed the FTC's rule. So you can't rely on EBR when delivering a pre-recorded telemarketing call to a residential line. You have to obtain express written consent for any such call. And I do note that the FCC goes out of its way to make sure in this, the rulemaking that it had, that this rule only applies to telemarketing calls and not pure informational and non-telemarketing calls. That is, those calls that I identified before, like surveys and research and nonprofit fundraising and that sort of thing. And also, this new rule does not apply to HIPAA calls.
Joe, we're getting a lot of people that are asking about the definition of prior express consent and the definition of between that and prior express written consent. Do you want to address that now or a little bit later?
Yeah, I can address that now. You know, the one great thing about the FCC rule is that it, at least the old rule, is that it didn't supply a definition for prior express consent, and that left a lot of leeway for people to kind of come up with what they determined to be prior express consent. Once you go to prior express written consent, however, and this is, you know, the FCC makes this clear, you're talking about a writing that is signed or authenticated in some way by the consumer. And this can be done, you know, with a wet signature, or it can be done with an electronic signature. The FCC very kindly said, you know, the e-Sign Act will apply. But once you start talking about, you know, the e-Sign Act, you need to think in terms of the consumer is signing a document, and the consumer has to have the intent that they are signing the document and accepting whatever it is that they're supposed to be accepting. And so for those people that want to get express written consent in the online environment, and I've counseled many clients with regard to this, I have certain ideas as to what constitutes a sufficient knowing signature, electronic signature on the part of a consumer. So it's the change is quite dramatic to go from express consent with no definition to express written consent with a lot of guidelines with regard to how you have to go about getting that express written consent. All right, so hopefully I addressed that question. And moving on to the next slide, which should be issue 3, abandoned call changes. Is that right, Ryan?
Yeah, that's right. And a lot of people just want us to specify whether we're talking business to business or business to consumer as far as these rules go.
Yeah, the rules that we're talking about here, when it comes to the global rule governing calls to cell phones, the FCC does not really kind of break out, business-to-business calls as a separate category there. The language of the rule itself is very broad. You can't call any cell phone for telemarketing purposes unless you if you're using a predictive dialer, unless you have express written consent. So arguably, that also applies in the B2B context, and I say arguably because the FCC does not have any history that I've been able to determine in going after true business-to-business calls. That is, if you're a business and you focus on calling other businesses for the purpose of offering those businesses business goods, then that's something that you need to think about from a risk analysis perspective. And again, hopefully I answered that question. And of course, the second component of what we're talking about here are calls to residential lines, and that's just very clear that that's just calls to residential lines. All right, so moving on to issue number 3, abandoned call changes. And the old rule, measure abandonment rate every 30 days across all calling campaigns. Okay, the new rule, finally, is same as the Federal Trade Commission. So you measure your abandonment rate on a 30-day, successive day basis per campaign, and the only additional thing is that you have to disclose that the call, under the rule, it says that you need to disclose that the call was for, quote, telemarketing purposes, along with the name and telephone number of the seller. And some people interpret the quotation marks as saying you have to use that phrase, telemarketing purposes. Others interpret that to mean, well, as long as the recipient of the call understands that this was for telemarketing purposes, then you're okay. All right, moving on to the next slide. Automated opt-outs. All right, what do you have to do in terms of when you're sending off a pre-recorded call that is allowed under the rules? What do you have to do? The FTC requires that you have to have an interactive voice or key press opt-out, and it's got this weird thing about whether the call could be answered by a person or it could be answered by an answering machine. But under the FCC rule, the only difference is the FCC requires the opt-out during the abandoned call message. And there's a big difference from the FTC. If you're using a predictive dialer, you have to send off an abandoned call message. Under the FCC rules, which pretty much govern everybody, you have to have the opt-out included as part of that abandoned call message. And there needs to be a toll-free number that's disclosed during a pre-recorded telemarketing message that are, in fact, left on answering machines. So, you would think that when it comes to automated opt-outs, the FTC and the FCC could kind of get together and just standardize what is required. I think the industry has done a great job of working in automated opt-outs into pre-recorded calls, but we still have some nuances that you need to take into consideration. All right, now I think I don't want to take too long here, but let's move on to the next slide, which is implementation. I think a lot of telemarketers were under the impression that, hey, once this goes out, then that's it. You have to implement it right away. And that's not a bad approach to take because, at some point in the future, this is what is going to be required, so you may as well start now putting that into place. But the fact is, there are some pretty lengthy time periods for implementation of these rules. First of all, the starting point is the publication by the Office of Management and Budget's approval of the regulations as issued by the FCC. Now, I'm not sure exactly, what the rules are with regard to why OMB has to review this. The way it works is OMB takes a look at new laws passed by Congress, and I think it reviews laws certainly under the Paperwork Reduction Act, and that's something that has to happen. And I don't know how backed up OMB is at this point. I think they probably have their hands full with Obamacare and all sorts of other regulations. But the start point is publication by the Office of Management and Budget's approval in the Federal Register. And then, once that happens, and by the way, it has not happened to my knowledge. If anybody knows differently, please let me know. There's a 30-day period for the abandoned call rule, 90-day period to put in the opt-out mechanism for pre-recorded telemarketing calls and abandoned messages, and then a 12-month period for phasing out the established business relationship exemption for pre-recorded telemarketing calls to residential lines, and a 12-month period for implementing the rule that prior express consent has to be in writing for predictive dialer calls to cell phones. So there is, certainly when it comes to the 12-month periods, a very lengthy amount of time available for entities that, for whatever reason, were not covered by rules that gave them the ability to send off pre-recorded messages with only express consent or with only a established business relationship. Those companies have 12 months within which to retool and kind of come up with new marketing campaigns or whatever it is that they need to do. All right, so Ryan, I think I've done pretty good in following the allotted time that I'm supposed to follow, and with no further ado, I'm going to turn this over to David.
Joe, thank you so much. That was very instructive and informative, much appreciated. Thank you everyone for participating on this conference call. Forgive my voice. I'm starting to lose it due to a cold, but just bear with me here. I'll try to speak as clearly as possible. We're going to talk today about automatic telephone dialing systems, and I'm going to probably refer to that phrase as ATDS just to simplify things. So anytime you hear ATDS, that's an automatic telephone dialing system. We're going to talk about what is that under the TCPA, what is it under the FCC rules, how the two work together, what is the case law interpretation of the ATDS rule, and what is this whole thing about preview dialers, and does that get me out of liability under the TCPA because, quote, I'm not using an automatic telephone dialing system. So
let me interrupt you and just kind of
sure.
Go through the results of our poll, because that'll help you understand the types of technology people are actually using that are on the call today. So we had about 75% of the about 280 people that are with us today vote on the poll. 24% are using a pre-recorded auto dialer robocalls, which I was surprised. 48% are using a predictive dialer. 27% are using a preview dialer. 66% run manual calls, and 11% run other. I don't know what other would be, but but that's the makeup.
Maybe smoke signals.
Yeah, there you go.
And Ryan, what was the number for pre-recorded?
24%.
Okay. Great. Well, that gives me a good barometer here. Thank you all for participating. So without further ado, real quick, TCPA defines what an automatic telephone dialing system is. That's right in the heart of the TCPA, 47 U.S.C. 227A1. And basically, the equipment that you're using has to have the capacity, and that's the key word here, to store or produce numbers to be called using a random or sequential number generator. Again, it's the capacity to store or produce numbers to be called using a random or sequential number generator. Now, so many people have said, what the heck does that mean? Not many people know. We're going to discuss it. We're going to try to get some clarity. And what basically, in part, that means is that the dialer that you're using should have a random or sequential number generator program. From what I understand, and maybe this is another poll that we could take at a different time, most of you are not using dialers that contain random or sequential number generator programs. Please talk to your IT people immediately to find out if they are, because that is the type of technology that most of the telemarketing industry was using back in the early 90s until maybe the mid to late 90s, but then they got wise and took out these programs in an attempt to circumvent potential TCPA liability with respect to using a dialer. We're going to talk about the FCC's 2008 ruling. That is key. We're also going to mention the 2003 ruling, but it's really the 2008 ruling is key because they made a specific pronouncement there. And in that ruling, the court said that using a predictive dialer, and what they meant was just dialers generally, they're saying that that type of dialer falls within the purview of the TCPA because in their opinion, it is a dialer that has the capacity to dial without human intervention. The 2003 and 2008 orders discuss why they have this particular ban and why they have what they're trying to prevent by use of the dialers and what type of numbers that they're trying to call. But the whole problem is that the whole purpose that they have articulated really doesn't apply today, and it's not going to be relevant. We're going to get into that in detail later. Next slide. So with regard to an automatic telephone dialing system, one decision that has come out that has been favorable to the industry in some regard is a Ninth Circuit decision. That's a Ninth Circuit Court of Appeals decision called Satterfield versus Simon & Schuster. And in this case, basically, the Ninth Circuit Court of Appeals said this. In looking at the TCPA and in looking at the statute, the phrase capacity to store or produce numbers to be called using a random or sequential number generator, which is the definition of an ATDS, is clear and unambiguous. Since it is clear and unambiguous, that is the end of the inquiry. You don't have to look for a specific definition. Congress has defined that term in the statute itself. That is the definition. You stick with that definition, and that's what you use. What's really important about the Ninth Circuit decision, it says you do not look to any FCC or regulatory agency interpretation of what is an ATDS because there is no need to define it. Congress has defined it, and once Congress defines something, the Supreme Court law says that you stop there, you don't look any further, that's the end of the inquiry. That is basically the law of statutory interpretation. In this Satterfield decision, why it's also important, it also holds that a text message is a call. So therefore, it is a call under the TCPA, and also the court defined the word call. Basically, it is to communicate with or try to get in communication with a person by telephone. Real quick, let's talk about, well, what do you mean by Ninth Circuit Court of Appeals and who's bound by this and what does that all mean? Well, the Ninth Circuit Court of Appeals is the Federal Circuit Court of Appeals that basically governs all the federal district courts, which is the lower court or the first threshold of the trial level courts in Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, and I believe Washington State. So all of those states and those regions are basically bound by a Ninth Circuit decision. So if you were in a federal district court litigating a particular issue, and let's say this particular issue of what is an automatic telephone dialing system under the TCPA, you would cite to the Satterfield decision, and the court should be bound basically by that decision because the law of the Ninth Circuit controls the federal district courts sitting in those states. Next slide. Okay, so let's talk about automatic telephone dialing systems and really how Satterfield got into this whole case. What happened in Satterfield, in short, was that there was a summary judgment motion that the defendant filed, and the defendant said, hey, look, under the TCPA, I am not using a dialer that falls within the purview of the TCPA as defined. Well, the district court basically said, that is true, you're not using a dialer that falls within the purview of the TCPA, therefore we're going to grant judgment in your favor because you're not using a dialer that has the capacity to store or produce numbers to be called using this random or sequential number generator program. Well, the Court of Appeal, this case went up to the Court of Appeal, and the Ninth Circuit decision said basically this: we are going to say that the TCPA means what it says when it defines what an ATDS, and it says what it means, and we end there. That's the end of the inquiry. Don't look to anything else. However, there are two different experts in the cases. The plaintiff expert said one thing, the defense expert said another thing. The Court of Appeals in Satterfield decided that they were not going to decide the issue, and they could have. They just didn't want to take a leap of faith. And they said, you know what, we're going to send this case back to the district court, and we're going to let them decide based on the experts, does this particular dialer at issue have the capacity to store or produce numbers to be called using a random or sequential number generator? The district court unfortunately never had a chance to make that decision because the parties decided to settle. And unfortunately, by making its ruling in the Satterfield case, the Court of Appeal basically undercut this wonderful pronouncement that it made, the pronouncement that an ATDS is defined in a statute, and that's where you end it. They sort of undercut that decision by saying, well, we're not going to make the decision based on that definition. We're going to let the lower court make that decision. They never did. But the lower court could have easily said, I, as a lower court, cannot make this decision as a matter of law, meaning the judge on his own upon motion. And he may have said, there is a conflict between the experts. I'm going to relegate this to a jury. That's the problem here, because still we have nothing that conclusively says what is a dialer under the TCPA. We do have the Satterfield decision. It is a great decision. It does give Moxie to file a motion to determine that a particular dial is not a dialer as defined by the TCPA, but then again you could have a battle of the experts, and sometimes a judge will make a decision based upon a battle of the experts because a judge can make a determination as a matter of law. Sometimes the judges can't, and they will punt the matter to the jury, and that, of course, is the wild card. Another thing is, with regard to the determination of what is an ATDS by the Satterfield court, you still have to look to the FCC rulings here, and the FCC rulings are very powerful because the Satterfield decision, again, governs all of the states that I mentioned that are within the Ninth Circuit Court of Appeals jurisdiction. But if you're not, another court sitting in another state outside of the Ninth Circuit can say, I don't have to follow the Ninth Circuit law. I'm not bound by it. I choose not to. So that's an issue that you have to grapple with as well. We're going to talk about the FCC rulings here. Next slide. So as we go forward, we've got Satterfield, but we still have to say what constitutes the capacity to store or produce numbers to be called using this random or sequential number generator program. That has not yet conclusively been decided, so that is still up in the air. Again, Satterfield gives some moxie to challenge that most of the dialers that you are using today don't constitute dialers under the TCPA. But then we've got the FCC's 2008 ruling, and that ruling says when we're talking about dialers, we're talking about anything that has the capacity to dial without human intervention. Again, the capacity to dial without human intervention. The FCC looked at this whole issue about predictive dialers and dialers generally. The ACA International went to the FCC and said, please give the debt collection industry an exemption for the use of these predictive dialers because of the way they operate. The FCC says, no, we're not going to do that, and we're going to go a step further. We're going to say not only are we not going to exempt the debt collection industry for use of predictive dialers, we're going to say that predictive dialers fall within the purview of the TCPA because they have the, quotes, capacity to dial numbers without human intervention. And that capacity word is very broad. And that whole phrase is very, very broad. And if you think about it for a moment, the capacity to dial numbers without human intervention is an extraordinarily broad phrase. And people have asked, well, wait a second, that phrase in that 2008 ruling, it's only a small phrase within the part and context of an entire FCC 2008 ruling. Isn't that just mere commentary or mere superfluous language? Based upon the analysis that I have done, that language is part of a final FCC order and therefore becomes a final order itself. So everything in that order becomes part of a final order. And usually when you have a final FCC order that has already gone through the public comment procedure, and once that is completed and once the FCC issues a declaratory ruling or an order, it is a final order. And this is the trick. Federal district courts, again, those are the lowest level of the federal court system. Those courts are bound by FCC rulings, meaning that they cannot directly challenge or annul a ruling of that nature. That's called the Hobbs Act. So the Hobbs Act says only a federal court of appeals can challenge or annul or rescind an FCC final order. That's the problem. That's where the Satterfield case comes into play. The Satterfield case did not directly challenge the FCC's 2008 ruling. It didn't have to, because the Satterfield decision says you do not look to the FCC rulings when you are making a determination of what is the definition of an ATDS. But unfortunately, again, when we're outside of the purview of the Ninth Circuit, you have to look at the FCC 2008 rulings because they're going to impact whether your dialer constitutes a dialer as a matter of law. Next slide. So let's talk about what the argument that's in favor of the defense here. We have, again, the Satterfield decision, and one of the arguments that you make is that you do not look to the FCC rulings when you're interpreting what is an ATDS under the TCPA, because that's what the Supreme Court of the United States said in that Chevron case that I cite in that first paragraph. Once Congress directly speaks, that's the end of it. So that is one way to attempt to challenge, even in a district court level outside of the Ninth Circuit, whether an FCC ruling has impact or not. Of course, a plaintiff challenging that will try to raise this Hobbs Act and say, no, you can't challenge the FCC ruling. And even by raising the Chevron Supreme Court decision, you are indirectly challenging the FCC ruling at a district court level. You can't do that per the Hobbs Act. However, it's an argument that has to be made. There's another U.S. District Court decision. Now, this is only a federal district court decision, not a federal Court of Appeal decision. This is a decision out of the federal court sitting in Illinois. It's the Griffith decision, and basically the court in that case had an opportunity to look at the dialer that was being used by the defendant. It was just a standard dialer, sometimes used in predictive mode, sometimes used in preview mode, but generally, quote, a dialer, did not have a random or sequential number generator program. The court basically said, under the FCC's 2008 ruling, you are using a dialer that has the capacity to dial without human intervention. The court basically followed the 2003 and 2008 FCC orders. The court also looked at the Satterfield decision and said, you know what? We see the Satterfield decision. The Satterfield didn't directly address those FCC 2003 and 2008 orders. Me as a federal court sitting in Illinois, I'm not bound because I'm not within the Ninth Circuit. I don't have to follow Satterfield, and I choose not to, even though the Satterfield decision is certainly suggestive authority in that district courts. Even district courts can choose not to follow a Court of Appeal decision outside of their jurisdiction. So that's a real problem. We're going to discuss this in a little more detail. It's that capacity to dial without human intervention is the difficult pronouncement by the FCC here. Real quick, manually dialed calls, even when your PBX phone is tied to a dialer, if one of your agents is dialing 10 digits on the phone itself and it is not going through the dialer, even though that phone system may be connected technically to the dialer, that's a manually dialed call. And remember, manually dialed calls do not give rise to TCPA liability. If you're not using a dialer, not leaving pre-recorded messages, you don't have potential TCPA liability. No liability for manual dialing. Next. Let's talk about...
let me just jump in on the manual dial question, because we had some people ask some questions about that. And there's one other issue that pops up on a manual call to a cell phone in the telemarketing world. there is a restriction in 5 states that have additional rules where they essentially don't allow any calls to cell phones in those states. Those states are Texas, New Jersey, Arizona, Louisiana, and all 5 people in Wyoming.
That is true, and thank you for that clarification, Ryan.
Hey, are you going to go into the preview mode? So I'm going to, since I think this is a good point since you've just given the case law on this, to give people a quick little poll in terms of if our cell phone numbers subject to the FCC rules. So I'll give people, it's either yes or no, so we'll give people just a couple seconds to answer this quick poll and see what people think. We're getting lots of yeses. We'll give people a few more seconds. I mean, we get the question, we use everybody wants to kind of get around that regulation because the bigger picture is that there are actually more cell phone numbers now than landlines in the United States. There's actually more smartphones than there are home PCs in the United States. So obviously trying to target and get to your customers with a call to a cell phone is kind of mission critical in order to contact them. So and then in terms of compliance, it's really complicated because not only do you have to scrub for the carrier-owned numbers, you also scrub for New Star's list or the ported numbers that came over from a previous landline. And then the FCC throws another curveball at marketers, which is the 15-day update period. So normally if you're a telemarketer scrubbing do not call, you've got a 31-day grace period where the FCC's rules only give you the 15 days. New Star file, the ports gets updated daily, so you've got a tighter grace period. So the results of the poll show that 89% of people say yes. They think that the cell phone calls are subject to the FCC rules based on what we just threw at them. So I'll let you take that away, David.
Even yes, when used in preview mode. Let's talk about that.
Yep.
What most people call preview mode is basically dialing where the agent sits, a live agent sits, and before a particular call is launched, the call is either sent by the dialer or by other software directly to the live agent. The live agent sees the telephone number on the screen and then makes a decision to launch that call by depressing a key. Let's say, for example, the F1 stroke. And a lot of companies are using their dialers in preview mode in order to attempt to get around the FCC pronouncement that a dialer is anything that has the capacity to dial without human intervention. Well, the question is, does dialing in preview mode, if that's what you all are considering preview mode, a violation of the TCPA and possibly the FCC rules? Well, again, if you're dialing in a preview mode, it's not so much the mode you're using, unfortunately, it's the dialer. Look, if you're looking strictly at the Satterfield decision, an argument could be made, well, first of all, I'm using a dialer that doesn't have the capacity to store or produce numbers to be called using a random or sequential number generator. So no matter how I use my dialer, it doesn't fall within the purview of the TCPA according to the Satterfield decision. However, if you're outside of the Satterfield decision, the question is, does that dialer used in preview mode fall within the purview of the FCC's 2008 pronouncement on what is a dialer? The answer to that is potentially yes, because the question is not how you're using the dialer, but does that dialer have the capacity to dial without human intervention? That's the key. And most dialers to do, unless you're completely reconfiguring the dialer itself, just using it, let's say, for a temporary period or for a particular group of hours or on a given day or during a given week, unless the dialer is completely reconfigured such that calls cannot be made from that dialer without human intervention, then an argument can be made that the dialer still has the capacity to dial without human intervention, and that's the problem with that FCC ruling. Again, the Chevron Supreme Court argument can be made. It's a tough argument to be made, but certainly could be made. And again, at the federal district court level, you're going to get a challenge by the opposite side, by the plaintiffs under the Hobbs Act. So That's something that you must always keep in mind. So again, going on to the next slide, when you're looking at the FCC's impact on preview dialing, and basically under this Griffith decision and under the FCC's 2008 ruling itself, I think that the court would say, hey, look, your dialer basically has the capacity to dial without human intervention. I know that you're using it in this preview mode and you've got a live person there, and that live agent has to actually depress a button in order to launch the call. And yes, that is human intervention, but does your dialer have the capacity? And again, this is problematic, and the language is so broad, it is overbroad, and believe me, there are challenges to this language as we speak because it doesn't make sense in the context of what the telemarketing industry is trying to do today. It also doesn't make sense in the context of what the collection industry is doing today, but this is what the FCC's recent pronouncement is, and unfortunately, it will likely be deemed, quote, a final order that has to be followed. Okay, so this is another issue that I think where there's a potential challenge, and again, it's a difficult one, but the 2003 and 2008 FCC rulings also discuss in detail this purpose of the auto dialer ban, and they have said specifically in those orders that the reason why we want to prohibit certain technologies from dialing numbers is because we want to prevent the dialing by these dialers of these emergency numbers, healthcare facilities, and telephone numbers assigned to wireless numbers, and any other number for which the consumer is charged for the call. So according to the FCC, those particular practices were determined to threaten public safety. They inappropriately shift marketing costs from sellers back to consumers, and they think that these auto dialers can dial thousands of numbers in a short period of time, thereby tying up telephone lines and calling a further, quote, threat to public safety. That was their pronouncement back in 2003, which stemmed even from a pronouncement years and years back. But that doesn't really apply today. Those pronouncements and those reasons for why they said we want to ban a certain dialer technology doesn't make sense. So the argument needs to be made that the 2003 and 2008 rulings and the purpose of the auto dialer ban is basically irrelevant today. There is enough bandwidth, and especially on VoIP, there is enough bandwidth, and there isn't the tying up of thousands of lines and a threat to public safety, and the numbers being dialed by the telemarketing industry today are not targeting emergency numbers and healthcare facilities. So, and there isn't a threat to public safety, and there's not a, quote, inappropriate shift of marketing costs from sellers to consumers that maybe existed back in 1991. We are in a whole different milieu, a whole different atmosphere. So that's another argument that could be made as to challenging the 2003 and 2008 FCC ruling. Again, it prior express consent, as Joe said earlier, you leave a pre-recorded telemarketing call, you need to get prior express consent in writing, and unfortunately the EBR exemption no longer will exist. So that's basically where we are today. That's basically where we are with dialers. I know this is very tough. I know it's very heady. I know it is very complicated. I fleshed out at least my portion of the PowerPoint in a lot of detail, giving you the law so you can look at it again, digest it, and talk about how you can deal with this in the context of the dialer you're using, and in the context, of course, in trying to secure prior express consent, because of the danger of that FCC ruling, especially when you're outside of the Ninth Circuit Court of Appeals.
Yeah, David, thank you very much. That was a good breakdown, especially with the preview dialers. I think a lot of people are surprised that that does not technically get you around the rule and that there's case law out there. And just to fill in on the other, two people texted us as far as the other dialer technologies that they're using, that falls really, I think, under the SMS. So that's what one person suggested, which makes sense, that text to customers are actually treated as phone calls, as you kind of pointed out.
Right. So if you are texting, then you're under the same rules, unfortunately. If you're calling a cell phone without prior express consent, if you're texting a cell phone without prior express consent, you still need to get prior express consent. That's the key, and we understand how difficult it is to get, especially in writing.
So just to recap, the only safe way to call a cell phone number would be to dial the phone manually or with a system that's not attached to something that has the capacity to make automated phone calls or store numbers, which kind of puts it aside, out of even the ballpark of a traditional preview dialer, which some people are really confused on what a preview dialer is versus a predictive dialer.
Well,
predictive dialer, basically will go through and call a list of phone numbers, and as soon as somebody says hello, they connect to a pool of agents. Usually there's a small delay when they connect the call, and then where a preview dialer basically is where you have the agent readily available, and a lot of people will refer to that as a one-on-one call. That agent is there ready to take the call either by clicking a button or dispositioning a last phone number, and it's not going on off of a pool of agents.
Right. And again, if there are certain dialer companies and there's certain ways that you can comply with the law. I know it's very, very difficult. I know prior express consent is extraordinarily difficult, and I know that using the dialers is difficult today, but number one most important thing is talk to your IT people to make sure that your particular dialer does not have a random or sequential number generator program in it. Again, most of the dialers that all of you are using today do not have such a program in it. Your dialers can't generate sequentially or randomly numbers on their own. But that's the key, because that is at least the way the TCPA still is written, and that is at least what one Federal Circuit Court of Appeals in Satterfield has held is, quote, the definition of a dialer as a matter of law.
And the other issue that we did have, I think 24% of people that are using pre-recorded call campaigns. That is the number one enforcement issue with the FCC right now. They are continuing to get a flood of complaints about pre-recorded calls. They have brought down a number of cases this year involving the dialer companies or campaigns that are run even offshore. Somebody asked about an offshore campaign, whether that's exempt. I mean, if you're calling in the States and you're offshore, you're subject to the rules as if you were onshore. There may be enforcement issues to some extent, but the FCC has a joint task force with Canada and with an international committee now where they're going after those entities. The gentleman that was involved in the last enforcement action with SBN, he had bank accounts in Hong Kong. They seized his assets for, I think, $3 million. So offshore doesn't really equal getting away from these rules. The FCC is pretty savvy when it comes to targeting providers of pre-recorded call campaigns, and they're very aware of the amount of complaints. One of the things we didn't talk about was the political calling, which may be driving the amount a little bit as far as complaints on pre-recorded, because political is exempt. They're exempt from FTC rules, but I don't know if David or Joe wants to address the question of whether politicians also need to scrub cell phones or if they're subject to the FCC rules. That was a couple of people asked that question.
Well, David, if you don't mind, I'll jump in on that because I've been kind of dealing with that quite a bit. Based on the reading of the rule from the FCC itself, yes, even political pre-recorded calls delivered to a cell phone would be covered and would be banned under the FCC rule unless you had express consent. And I'm sure there are people on the phone right now who are saying, well, why did I get political calls on my cell phone? And I will just say that there are some providers of political calling services who take the approach that if, when you are putting information into the voter roll for your state, and you have to put in your name and your number and contact information, and if you put in a cell phone number to your voter roll, they will consider that to be express consent to receive political phone calls. And so that's the explanation for why politicians, they may, in fact, go out there and call numbers that have been placed on voter rolls. And so far, there's been no enforcement with regard to that. And I don't anticipate any enforcement with regard to that because, the FCC is certainly, and the FCC as well, very cognizant of, political speech and the protections out there for political speech.
And Joe, would you also say that with respect to, on a slightly different topic, just the pre-recorded calls in general, that since Ryan said that it is the #1 enforcement under the TCPA, would you recommend that you would ensure that all of the clients who are leaving pre-recorded message calls do so with express consent in writing?
I try to think as broadly as possible in order to provide my clients the best possible advice that I can give. If you're sending off telemarketing pre-recorded messages, absolutely just that is the highest number of complaints that are being received by the FTC and state AGs. So that is very, very problematic. So absolutely, if you're sending off telemarketing pre-recorded calls, then you have to get prior express consent. And the next step is, all right, well, what about all those informational calls? And, even those informational calls will generate complaints by people. And, well, if you have express consent of some sort, and that's where things can get a little, questionable, I guess. You have more broad leeway as a person sending off pre-recorded messages to define what exactly express consent is. And a lot of people rely on express consent as, if you click through on a website, and on the first page it says, oh, by the way, by clicking through to the next page, you're providing express consent to receive pre-recorded messages of this, that, and the other type. Is that sufficient? I have to review that on a case-by-case basis.
Thank you, Joe.
So some of the express consent, we had a lot of questions on what is express consent, and regarding the e-sign act, if that helps to record phone calls. I mean, is there something, like you're saying, you have to kind of look at it case-by-case basis because express consent can mean a lot of things, but it's really the onus is going to be on the marketer to be able to prove it if they're doing pre-recorded calls. If they're calling cell phone numbers on a dialer, you have to prove that that consumer physically opted in. There's a lot of third-party websites where they will sell opt-in leads.
Yeah. Well, let's put it this way. If you're going after express consent, I'm going to say you have some leeway to maneuver in terms of how it is that you define what express consent is. If, on the other hand, you have to get express written consent because you're sending off telemarketing pre-recorded messages, you don't really have much leeway. You have to get a signature, a knowing signature by a person who, with the intent to sign whatever it is, whatever form it is that you are presenting to that person. And that's where it can get tricky. That's where a lot of entities out there might try to cut corners and make assumptions about what intent is and what a signature is. But the e-sign act is it actually is reasonably exact with regard to what is required. And again, if anybody has follow-up questions, I can be contacted at jws@sansgrant.com because it really does come down to a case-by-case analysis. Every website is different. Every the disclaimers that a company wants to use, they can be different. So that's a case-by-case analysis.
And we're looking at a lot of opportunities now where people are really saying, okay, we're going to have issues calling cell phones. It's probably going to be in a year or so. The OMB has not published a rule. What should we do? What would you advise? You know, you guys are our compliance company. You guys have our databases, and what we've been doing is really just saying, okay, you've got, let's say, 500,000 customers. Of those 500,000, 300,000 you only have a cell phone contact. So maybe you want to go back and to the people that you only have a cell phone number and ask for a landline, or ask for the permission if that's the number they want you to contact them, so that you have that consent in writing, so that you have that permission. So for the people that were able to make it here in the webinar today, if you guys, if any of the companies here want to just run a quick analysis, get a count on what's on file, and do a sample, happy to do that at no cost as kind of a free review. We'll also have a tool that will give you guys a free registration for the states that you may need to register, which everybody should look at because the states are really kind of cramping down on that as well.
And just another point, be proactive with getting that prior express written consent. That is for clients that you're already dealing with, and you want to be able to contact them later for upsells. As part of the invoicing process, as part of the contractual process, you're going to want them to check a box or do something that indicates that they are giving express written consent to receive calls onto their cell phone number. And that's something to be proactive on. Try to change your materials in such a way that you're obtaining express written consent as much as possible. That's another suggestion. And also, by the way, for those entities that want to get express written consent for them to make a follow-up phone call, keep in mind that you may want to share your lead lists with another company, and you need to include language in whatever it is that you're using to the effect that the consumer is giving permission to have affiliated entities contact them as well. And there are some specific, not so much rules on that, but if you look at enforcements that the FCC has done, I've generated some guidelines with regard to how to go about getting sufficient permission from the consumer for calls from affiliates.
And I think that's really important because a lot of people have relied on the fact that they think there's this EBR for calling cell phones for a number of years, even though technically it hasn't existed. So a lot of people are questioning, well, what do I have to do now? Can I use my EBR? The fact that they're my customers, they've given me their phone number to call them on the dialer. And I would say the answer seems to be no, that is not sufficient. FCC is saying you need to have written for consent, which is why there's been a lot of buzz about these FCC rules, because that's not so easy to get from every consumer that's out there.
And Joe, doesn't that written consent also require, and Ryan, doesn't the written consent require that the written consent state that such consent is to be able to make a call to the number via an automatic telephone dialing system or a pre-recorded message?
Yeah, I see where you're going with that, and I don't come down quite that hard. There was some indication with regard to that in that Leckler case out in California that was problematic, but luckily all that Leckler stuff went away. And so I don't necessarily counsel my clients that they have to include language that says, I, the consumer, am agreeing to receive calls from an automated telephone dialing system, something like that. That might, scare the squirrel away a little bit.
And we don't think when the final FCC order comes out from the OMB that they're going to require that.
No, I don't think that. I don't think that's the case.
Great.
My feeling is that so long as you are providing sufficient notice to the consumer that they are giving consent to receive phone calls, either at the residential line that they put in or the cell phone number that they put in. And if you want to add in something along the lines of including pre-recorded calls, I think that would be sufficient.
Let's take one last question. I think the advice there is, yeah, there's a lot of different ways you can go about the type of language you need to have. The question that has come up with several times is taking a step back on these rules, business to business versus business to consumer. It sounds like if you're running business to business calls, you're running a dialer, pre-recorded or predictive or even preview, a call to a cell phone number still can get you in hot water because the FCC doesn't differentiate between the two, whereas the FTC's do not call rules do specifically provide an exemption for business to business,
Right.
business to business telemarketing.
Yeah, and this, you know, the one area where you definitely can run into problems is the false business number. That is the home number that is being held out as a business number. That is, you know, you might be making phone calls to what you consider to be a true business list. And on that list, there could be a significant percentage of numbers that are just standard residential numbers, and the entity that compiled that information into a, quote, business list made certain assumptions about, you know, what constitutes a business number, and that's how they collected that information. It's a problematic thing. You know, there really doesn't appear to be too much of an answer to it. And that just is something that companies need to take into account in terms of risk when they are doing a B2B campaign. But if you are doing a B2B campaign and the list that you have is strictly numbers that are identified as business numbers with whatever telco the number has been registered with, you're in a pretty good place. Because that is and so long as you're calling up the businesses to offer them business goods, then you're in a pretty good place.
Yeah, and I think a lot of the companies we deal with these days are really kind of in complaint avoidance. Consumers will file FCC, FTC complaints pretty quickly, and so even if you're trying to target businesses, you may have some cell phone numbers on the list, you may have numbers that some home-based business put that number on the do not call list, and even if you call it and they file a complaint, it's not that you're maybe doing something that falls within the law, it's that there's a cost to defend that complaint. There's an admin cost to respond to it. You might have to have Joe or David hire him as an attorney. You have to maybe pull your records from us to see when you scrub the number, et cetera. So a lot of people take the, let's take a very non-risky approach to running our calls. Because under TCPA, a lot of people are out there, not a lot of people, I would say there's a cottage industry of people that file suit on telemarketers. They try to collect their $500, $1,500, and so there's a lot of them. I've been getting a lot of calls lately from clients that are getting consumers that think that the cell phone rules are already in place, and they apply to everything. Well, you can't call, you know, they argue with them and say, well, you can't call me on my cell phone. They don't know anything about the dialer rules. All they know think is that you can't call me on my cell phone. And so they have to backtrack and respond to the AGs or wherever they're getting complaints from, or the consumer themselves. So it is kind of a wild world out there in terms of what the industry has to comply with versus what has also been promoted to the consumers and what's been in the news. So
all right,
you guys
there
have
we go.
anything to add there, David or Joe, as far as
No, nothing to add other than you know, standard thank you to you, Ryan, and to David for being on the call today, and thank you for the opportunity that you gave me to be on the call.
And thanks to you, Ryan. Thanks to you, Joe. Much appreciated. And again, if anyone does have any questions, you can call Joe or me. And if anyone has any questions regarding TCPA generally or their dialers, feel free to give a call when you get a chance. All our numbers are listed on the seminar materials.
And of course, all the latest updates regarding FCC and state developments are included in at dnc.com on their compliance guide, and that's something that I highly recommend that people get.
Yeah, I mean, that's really the best way to keep on top of this stuff, where we put out newsletters, email alerts, we've got all the regulatory information analysis. It's also where we're going to post the recording of the webinar when you'll get it, so you can feel free to click around on that. It's really about the best resources you can use to stay on top of this. So I appreciate when everyone joined today, and like I said, we'll get the deck out with the recording. If you guys wanted to check out the free wireless analysis, let me know, or the compliance guide. You can just, like I said, we'll get you over there to dnc.com, and it's a pretty easy tool to figure out where you need to register and those kinds of things. So hopefully we covered as many questions as we could, and a lot of content in here. So again, feel free to grab that recording when it gets out there, probably next couple of days. And if you have any other suggestions for content next time, let us know. Appreciate it.
Excellent. Thank you, Ryan. Thank you, Dave.
Okay.
Thank you all.
Okay.
Bye-bye.
Bye-bye.